Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Manisha Patel presenting for us. If you are unfamiliar with the format of this event, first, Manisha is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or in the comments section on Facebook. We'll review all questions put in the chat boxes during that Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Be sure not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Manisha to get us started.
Thanks, Marissa. Well, we're going to go ahead and get started with this Listen and Learn clinic on child custody. As Marissa mentioned, my name's Manisha. I'm a volunteer attorney with Legal Aid of North Carolina, and I wanted to share a little bit about Legal Aid and the wonderful work that they do in North Carolina. They are a statewide nonprofit law firm that provides free legal services for civil matters to low-income people to ensure equal access to justice and remove barriers to economic opportunity. Here listed on the PowerPoint are some areas that legal aid assists with: housing, employment, education, DV, disaster relief, consumer matters. If you're interested in any of this information, here is the contact info, or excuse me, the information of Legal Aid's website. And I know Marissa has put all the links in the chat as I mention them. Legal Aid also does monthly listen and learns for these matters. We're here for custody today, but there's also simple divorce, criminal expunsions, tenant rights, Social Security disability, Medicaid rights, SNAP, emergency SNAP, Medicaid eligibility, healthcare POAs, and living wills. And so again, Legal Aid of NC, legalaidnc.org is the main website, and then the link is in the chat if you're interested in signing up for any of these other monthly clinics, I call them, to participate or get more information of how they work. So what about today? What are we going to do today? First thing, as Marissa mentioned, Legal Aid does not represent you. I do not represent you. This is purely informative. This is for the intent of today's session is for pro se. I'll say that a few times. That means without an attorney, on your own. And so for self-representation, for the initial filing for custody and or visitation rights in North Carolina only. So those are some of those precursors. If those don't apply to you, then maybe just listen and see if this information might be helpful for you in the future. But North Carolina, initial filing, child custody or visitation. This clinic today is going to help you file the initial action and kind of walk you through the paperwork process. And then again, if there are questions, drop them in the chat, the Q&A box, and make them as general as possible. Okay, now if you already have a custody case pending, so what does that mean? There's already been a custody order signed by a judge or something in the court system that is ongoing or happened many years ago or even a couple years ago, and you want to change something of an existing order, then you do not need to file again. You need to file a motion to modify. If you need information about a motion to modify child custody and or visitation, we can get you some information. Just put some something in the Q&A, and I'm sure we can work with legal aid to get you some additional information. So again, if you have temporary custody pursuant to a domestic violence protective order, so that's the DVPO in this PowerPoint, this is still applicable. This still applies to you. You can still stay on and learn about how to file an initial custody action. So with that, let's get started. So first, we're going to talk about the law. So what law in North Carolina governs children's matters? I say children's matters like child custody. I'll mention child support briefly about how that's different from child custody, but here we're talking about custody. We're talking about physical custody and legal custody. When and how do you see your children, and who makes the decisions for your children? So first, our first section of our statutes is North Carolina General Statutes section, I might call it chapter 50. We have, and also chapter 50A. The specific statute that talks about child custody and child custody mediation is 50-13.1. If you even just Google NCGS 50-13.1, it will take you to the North Carolina General Assembly's website, and you can see the actual text of that specific statute. So now that we have, and let me mention before I go to talk about the legal standards, Chapter 50A, Section 50A talks about child custody more specifically. So what that talks about is specifically jurisdiction and enforcement of child custody orders. So if there are any questions about, let's say you have a child custody order from California, but now everyone lives here in North Carolina. That Chapter 50A has all the statutes of what does that mean? How is that effective? Is that effective in North Carolina? So that's what 50A talks about. For jurisdiction, so different states, different courts, and enforcement of different custody orders, however they enforce. So talking about the legal standards. So with custody, I often get questions from parents, grandparents. I get it from godparents. I get questions from siblings, adult siblings. So what are the legal standards for all these different types of people? Step parents is another common one. So the first is for parents, for biological parents. The legal standard for custody is what custodial arrangement is going to be in the best interest of the child or children. That has a lot of, it's it's 5 words on the screen right now. So what does that mean? We'll delve into that a little deeper, but best interest, I think of it as who or what custody arrangement is going to best promote the welfare of the children. And by welfare, I'm talking about physical welfare, moral welfare, emotional welfare, spiritual welfare, and emotional. Did I say spiritual, physical, moral, mental, and emotional? Yeah. So, what parent or what arrangement is going to best promote that welfare of your child? And when I say a custody arrangement, I'm not talking about just where's the child sleeping physically each night, but who's making the decisions for the children or child, the major life altering type decisions. Legal standard for non-parents. Well, first, before you can even, as a non-parent, try to get custody, you have to have standing. What is standing? Before you can even get to best interest, you have to prove to the court that the bio parent, the legal parent, parent on the birth certificate, because sometimes a biological parent may not be on the birth certificate, or there might be a parent on the birth certificate who is not the biological parent. So that's one kind of nuance we have to figure out. But also, is that person, is the biological and or legal parent or parents acting inconsistent with their constitutionally protected parental rights? Now, Those are a lot of big words. What does that mean? That means under our North Carolina Constitution and the US Constitution, the constitutional right to parent a child, your offspring, is such a highly protected right that a judge must adjudicate, has to find that a bio and or legal parent is acting inconsistent with that right. Now, what does it mean to act inconsistent? Well, acting inconsistent is essentially not acting in the best interest of the child. Now, think of an extreme, child abuse, sexual abuse, fleeing the state of North Carolina to evade the courts. Those are things that called acting inconsistent. If DSS is involved, the abuse, dependency, neglect courts, that's a way that you could allege and have to prove to a judge that a biological parent is acting inconsistent. And so for short, throughout this presentation, I'm going to say acting inconsistent instead of that big mouthful. But those are some examples of what that means. Now, I mentioned earlier, non-parents. Who's a non-parent? Well, in North Carolina, a grandparent has specific section in our statutes, 50-13.2, that talks about grandparent visitation. And so remember, when I say visitation here, I'm going to make a distinction: grandparent visitation and grandparent custody. Two completely different things and two different standards. So that's the statute if you want to look that up about grandparent visitation, and what circumstances would a court offer or allow grandparent visitation. We're not going to talk about that today. We're talking about an initial filing of a parent or a non-parent who wants to file a brand new lawsuit for child custody. Now, I want to go through some definitions so you all know what I'm talking about. Okay, so plaintiff and defendant sound very adversarial, very combative, aggressive. All it means, plaintiff is the first person who files a lawsuit, defendant is the other party. In civil cases like family law cases, plaintiff and defendant, it doesn't give anyone an upper hand if you're a plaintiff. All it means is you filed first. So just keep that in mind. Plaintiff is the first person who files a lawsuit and defendant is the other party. Pro se, I mentioned that earlier. Pro se, what that means is you are not represented by an attorney licensed to practice in North Carolina. So when you file an action, a lawsuit in North Carolina without an attorney, oftentimes you'll hear that the plaintiff was pro se or the defendant appeared pro se in court, meaning without an attorney. Primary custody, I'm going to kind of throw in secondary custody because primary custody can mean a lot of different things. It's a very broad term. And so let me actually talk about secondary custody as well before I define primary. Primary is who makes the decisions, who has more overnights than the other parent. Secondary custody, I use that visitation as a form of secondary custody. Secondary custody can look like visitation like every other weekend. It can look like only Thursday dinners every week. It could look like you have Saturdays from 9 to 5 p.m. and 9 a.m. to 5 p.m. and that's your visitation. Secondary custody can also mean supervised visitation, supervised visits. So secondary custody is kind of another broad term of who does not have majority of the physical time. Okay, so legal custody and physical custody. I mentioned that again earlier. I always get ahead of myself in these presentations, but physical custody is who has the child, who physically has the child in their presence, and where's that child sleeping at night. If that is with mom, then mom has physical custody on Mondays and Tuesdays. If it's with dad on Wednesdays and Thursdays, then dad has physical custody on Tuesdays and Wednesdays and Thursdays, whatever I said. Legal custody. What is legal custody? Now, this one oftentimes kind of trips people up, but I equate legal custody as who is making the life-altering decisions of the child or the children. Life-altering decisions, education decisions like school choice, that's a very common, a very big one that comes up. Who's making medical decisions? I saw a lot of this come up back in 2021, 22, about the COVID vaccine. Who's making the decisions about the vaccines? Should your child have their wisdom teeth out if it's not medically necessary? Who makes that decision? Who pays for it as a child support issue, but who makes that decision? What church does the child go to? Does one parent have the ultimate say of the religion choice, or do both parents have to equally make that decision? So legal custody is more of those monumental like life decisions for your child. Oftentimes I find that the courts default to joint legal custody unless there's a parent acting inconsistent, and it's a really high bar. But other than people, let's say if they agree that one parent's going to have the final decision making abilities or have sole legal custody, most of the time a judge is likely going to talk about joint legal custody and then kind of break into the nuances of the physical, of the schedule with the child. Okay. So who can sue? Who can file an initial child custody lawsuit? So we talked about parents, so bio parent, legal parent, who's on the birth certificate. It could be a relative. We talked about grandparents, adult siblings, aunts, uncles, godparents, a person. A godparent is a non-blood related person. Agency, you see this often with when there's a DSS case and a child enters into DSS custody. So that is a state agency that could file an action. It could be an organization or an institution that is claiming a right to custody. Someone who has a relationship with the child or to the child, that's where I often see the godparent relationship fall in that category. But person. And remember what I said earlier, you have to prove standing. You have to prove that you have the ability to bring this lawsuit under our general statutes. Okay, where do we file this? Now, we file this in the district court division of our courts. Now, each county has their own magistrate court is a lower level, district court is where family law cases are heard, and then you have superior court. And I mention this because I don't want you to get confused when I mention clerk of court in the future part of this presentation. The clerk of court's official title is clerk of superior court. That still means our district court filings are filed with that clerk. That is the main place where we file all of our lawsuits in North Carolina based on the county where you reside or where the other party resides with the child. I always say a good rule of thumb of where to file is where the child is physically staying overnight. Where do they go to bed at night? If that is going to be Durham County, but another parent lives in Wake County, you can still file in either of those, but generally the default, the preferred place is going to be where the child is located. So when do we file? When do we file this initial lawsuit for child custody? Generally, it's if they're married parents, after you're separated. But in North Carolina, you don't have to be legally separated in order to file a custody action. And that kind of sounds a little convoluted, but if you know you're separating or you know you need to file a custody lawsuit, You don't have to be legally separated in terms of like divorce law to file a custody action. The other big important takeaway is the child must have been a resident of North Carolina for at least 6 months prior to filing the lawsuit, this initial custody lawsuit, for the court to have jurisdiction. And again, if the child is younger than 6 months, they have had to live in North Carolina their entire life. Now, this is part of that General Statutes Chapter 50A I mentioned, the uniform, we call it the UCCJEA, the Uniform Child Custody Jurisdiction Enforcement Act. So that's another mouthful, but those statutes tell us ask us where is the child's home state, and the definition of home state is the state where they have lived for at least 6 months prior to filing. So just keep that in mind, that when we talk about the forms, we're going to have to say, where has the child lived, not only for the past 6 months, but for the past 5 years. So the first step is, where have they lived for at least the past 6 months before the filing. Okay, parental rights. Now, I talked a little bit about bio parents, legal parents. Until there is a written court order, both parents have equal physical and legal custodial rights to their child. Now, let's say you have no order in place, no court judge signed document saying this is what your custody arrangement is. Both parents have equal rights to have physical custody of their child and legal custodial rights to their child. Law enforcement will absolutely not help you retrieve your child from the other parent, even if you have a verbal agreement or you wrote it down in an email saying you're going to have Mondays and Tuesdays, I'm going to have Wednesdays and Thursdays, and we're going to alternate Friday, Saturday, Sunday. Even if you have that in the email, law enforcement will not help, and they will say, this is a civil matter. You need to either consult an attorney or deal with custody through the court system. If you do try to contact law enforcement and they try to give you any legal advice, remember, I don't know every law enforcement, but generally the law enforcement is not a licensed attorney and they cannot give legal advice. So always just remember, if you have a legal question, seek legal advice. And I can surely tell you, law enforcement will not get involved unless there's a court order in place and the order says law enforcement has the authority to blank. Again, if your parental rights have been terminated. Now, when I say terminated, that doesn't mean you're not on the birth certificate. This means there is a court order entered by a judge, file stamped by the clerk of court, saying you no longer have parental rights. They have been terminated as it relates to this child. If that has happened, then you cannot file a custody action. Here's another piece. I mentioned child support briefly. Child support and child custody are two separate, distinct legal claims in North Carolina. We'll often call them child's claims, children's matters, children's actions. They can be litigated. They can be in one court lawsuit, one lawsuit together, or separately. You can do two separate lawsuits if you need to do that. Either way is available. Either option is available. Okay, so I mentioned physical custody, legal custody. Now let's talk about, and I brought up primary custody and secondary custody. So let's talk about that with the legal terms. What does that mean? So joint custody. This means that both parents share custody, meaning they have equal say in making major decisions for the child, which is that legal custody. And usually that child lives primarily with one or both parents. Oftentimes joint custody will mean somebody has primary physical custody and someone has secondary physical custody. As long as it's not just one person, both parents have some form of custody, custodial rights, it will be joint custody. Sole custody. What does this mean? This means that one parent has the sole ability to make major decisions for the child. That's that legal again. And child lives primarily with, excuse me, not primarily, completely with one parent. But the other parent may have some limited contact or supervised visits. You don't see sole custody very often, unless someone is talking about sole legal custody, but it does happen. Most of the time, courts will label things like joint custody if one parent has majority of the time and the other parent has a smaller amount of time with the child or children. Um, Visitation. Now, this one is another word that I will say, like, I shared earlier, it falls into that secondary custody. This means that a non-custodial parent, meaning a person who has sole custody or primary custody, this means the other parent, the non-custodial parent, has a right to see their child, their children, and that amount of time, the type of visits, it's determined based on the best interest of the child. And whatever a court decides, whatever the court orders, usually depends on the ages of the children, how close the parents live to each other, and oftentimes they will provide a schedule. And that's usually like the final thing that comes out of a custody trial. So sometimes you want to just make sure that, if you are going to trial, you put all of these, all these things into your argument, what you present to your judge, what the evidence is, because this will give the judge, the decision maker, the information, the tools to make the best custodial decision, meaning custody, for the child, whatever is in their best interest. And we love when a judge gives us a schedule because it's certain, there's no question. Oftentimes they can make it very, very specific too. So these are just some different labels, and I'll use these terms throughout this presentation. Okay, so before you file, what do you need? You don't need to file to get child support. You don't need to file to get welfare assistance. You don't need to file for school enrollment. And I will, say that with like a caveat and that little asterisk here, meaning as long as you're a biological legal parent, you don't need to file for school enrollment. Medical insurance, temporary child care, for biological parents, you don't need it for that. But if you have a disagreement or a dispute, or you can't talk to the other parent to figure out a schedule yourself, this is probably a good idea to file. Now, drawbacks to filing. Now, I'm a big proponent of co-parenting, of parents working together to figure things out for their own children. They're going to be the best people to make those decisions. So why would someone file, or why wouldn't someone file? It takes a lot of time. It takes trips to the courthouse. It can be expensive, meaning there are court costs. You have to take time off work. You might have to go to the court so many times that you have to use all of your time off from work. The court examines your personal life. Now, this I will say, especially now that all 100 counties in North Carolina are live on eCourts, every document you file with the court is in public record. And all of the findings, all of the evidence you provide at a custody trial, the court, meaning a judge, will examine to figure out what's in the best interest. And they put that in a court order. And all of that is public record. Anyone with an internet connection or the ability to go down to the courthouse can examine that. Your employment history, your physical health history, your mental health history, your criminal record, your personal character, your significant other, your new partner, your dating history, all of that. Um, that really just puts you under the microscope in public record. And also, if there is a disinterested parent who has not been involved in the child's life, they may get involved because this has raised an antenna to bring their attention to this custody action. And like I said, the judge examines all the evidence you present, and they make an order. They make the decision of how and when you see your child or children, and it may not be what you want. You might think it's going real great, and then the court makes an order, they draft the order, and it's not ideal. It's not what you want. So there are some drawbacks to filing a custody action. And I'm going to say this, this is not to scare anyone from filing an action for custody. Sometimes you have no choice and you need to. Let's move forward and talk about these other areas. This is kind of a really well-rounded list of what a judge would look at in a custody trial, and this is what I would urge each person considering filing a custody action to think about your own self-evaluation, your own history with your employment history, whether you're currently unemployed, you're working, a non-full-time job. What is that, and how is a judge going to look at that? Do you have any pending criminal charges or past criminal charges? How serious are those? Will a judge look at that and say, no, this person is not safe for this child to be around? They'll look at your driving history. This comes up more often than a lot of people think. If you have a history of getting, speeding tickets or driving while license revoked, or even something you would think as simple as a seatbelt ticket, that really comes into play when judges are considering, is this parent fit and proper person? Because if they have a history of speeding in the car, not wearing a seatbelt, not having a valid driver's license, how is a child going to be safe in a motor vehicle with that parent? Living situation. And also sometimes they'll look at your living history. They're going to say, what do they live in a single family home? Do they live with family members? Will the child have a safe, clean place to sleep? Do they have access to a good kitchen, bathroom? All of those things. Is the heat on? Does the heat stay on? Does the electricity get cut off? What are those situations of your home, your household? And if you do live with roommates, they will examine those. A non-relative roommate, if you have a roommate, a lot of people do, they're going to want to know about this roommate. Are they a registered sex offender? What is their criminal background? What is their employment? So a lot of these things will come back on, examination of yourself, but also the people you surround yourself with who will be exposed to the child. Mental stability, prior court orders, and then if you're asking for custody or visitation. So this is a really comprehensive list of things that a judge would consider when they are trying to make a decision on a custody case. And then also, this is a great list of things if you're preparing for a custody trial. Here are some great things that you want to present to put yourself in the best light. Okay, do you need a lawyer? Can you do this yourself? Well, the first question is, will the other parent cooperate or will they fight? Are they likely to get a lawyer? If they're likely to get a lawyer, will you be able to get one? I have seen people go through this process with a lawyer, without a lawyer, a combination. Here are some key tips that you should get a lawyer. Is if your case is contested, meaning you cannot agree to a custody arrangement with your co-parent and the other side has an attorney, or after you go through this clinic, you go through the custody, the file it yourself packet. you need help filling that out. And we'll get to that packet in a little bit. And I know Marissa will, oh, I think she already put the link to the custody packet in the chat. So I would say click on that, open it, and look at it as we're going through this. It'll be a helpful tool. Okay, here's the roadmap for the rest of our presentation, our time together. We're going to talk about how to complete the forms. We're going to talk about how to file the forms. We're going to talk about serving the defendant, so the other party, your co-parent, and then we're going to talk about mediation. Remember, I mentioned it's in our general statutes that custody mediation is required. It will be court ordered. And then if mediation is unsuccessful, what happens next? You go to court. You have to have a custody trial. So this is the organization of the remainder of our time together. Okay, so first, are you ready to file for custody? What do you need? Okay. These forms, I want you to, keep an eye on the numbers. The AOC CV-100 is our summons. The 750, all of these numbers, I'm going to stay on this slide for a minute so you can jot them down. The complaint for custody and visitation is going to be in the packet that Marissa linked in the chat. So make sure you pull that up. The domestic civil action cover sheet, oftentimes the clerks of each county have their own specific requirements. I have found that in many counties, at least in the ones that I practice, they don't require this cover sheet anymore now that we are on eCourts. I've actually had some assistant clerks tell me not to file it anymore. So that's one of the great things about our eCourt system, is that it kind of has cut down some of the extra paperwork. But we're going to go through this as if you are filling all these forms out and you're physically taking them to the courthouse to file. You do have the option to file electronically, but that's not the option we're going to talk about today. The Service Members Civil Relief Act Declaration, excuse me, that is a requirement under federal law and state law that you have to provide a statement to the court that the other party is not an active member of the armed forces, an active service member of the armed forces. Now, if they are, they get the opportunity to have court-appointed counsel if they're on active duty. Affidavit as to the status of the minor child. This is really important because you're going to need an affidavit for each child. So just make sure when you download this form, you save as once you fill out each child's information, because this is going to be required for each child. Optional is this petition to proceed as an indigent. Now, what that means is you are asking the court for them to waive any and all current and future court costs. There are court filing fees to file a lawsuit, a notice of hearing for a trial. And so if you are unable to afford those court costs, you can ask the clerk of court, the clerk of superior court, to waive that. So that we'll talk about that when we get to that form. I advise I would often say if you can type in these documents, that is helpful, because these will be in the public court file. It'll be accessible online, whether you file in person or online. And it's just, it is easier for the judge to read. When we file this in person, you want original and 3 copies of each form. So that goes, if for number 5, affidavit as to the status of minor child, if you have 3 children, you want the original and 3 copies for each child. Some counties may require additional forms. I'll talk about that in a little bit, but to access these forms, we're going to go to the next slide, but the website is nccourts.gov. Okay, here's like a screenshot of what the forms page looks like. If you jotted down those numbers from the previous slide, on the left-hand side of this screenshot, and when you go to the website, you will see form number. You put in that form number and it will give you the PDF. You can download the PDF, you can save it, and then you can fill it out. There are different ways to do it. If you don't have access to a computer at home, I would say you're better off going to the public library than trying to do this on your smartphone. If you have an iPhone or an Android or whatever, it's going to be immensely easier doing this on a computer than on your phone. Now, if you want to just look at it, that's fine. But if you want to type it in, it's going to make it a lot easier doing it on a computer. Okay. Petition to proceed as an indigent. Now, this was that optional one that I talked about on the form list. So this is the form AOC G106. This is asking the court to waive all the court costs and filing fees. Now, I haven't mentioned what is the court filing fee, what are the court costs. For a custody action, it is a civil lawsuit, so the court cost is $150. Possible additional fee that you may incur is a notice of hearing fee. That is $20. It can add up. So if you do receive food stamps, TAMP, SSI, or you were represented by a legal services organization like Legal Aid, there are other different legal organizations throughout the state that are also wonderful in specific areas of the state. If you are, then this is a great option for you to file and move forward with having all those fees waived. If you are not receiving any of those things, then the clerk, their discretion applies. So that's something that they will examine your petition when you go to file all your documents, and they will ask you questions. And if none of those apply and they say, no, I'm going to deny this petition, I don't think you meet the qualifications under our general statutes, then you need to, be ready to, one, prove your case if none of those apply, and then two, move forward with the filing if your petition is denied. The big thing here, and I'm going to show you the form, the petition on the next slide, is do not lie, okay? On anything I talk about today, any form, any document, any file it yourself packet, do not lie. You could be held in criminal contempt, civil contempt of court for giving false information on this form and any other form. And also this petition, it has to be notarized. You have to sign it and date it in front of a notary. A notary public will sign it, say that you are who you say you are, and they'll put their stamp, because that is proving to the court that just like sworn testimony in a court hearing, you have said that everything you've provided in this petition is true. You haven't been forced to put any information there, nothing's false, all of it's true. Okay, this is what that form looks like. So when you go to the nccourts.gov website and click on forms at the top, put in this form number. This is the PDF that will be there for you to download. And this will kind of show you all the different check boxes. And I always say you want to do petition to assert claims, the first check box. Honestly, petition to assert claims and file motions, I think those are appropriate for a custody action. So just keep that in mind, which boxes you are checkboxing. Now, if you make an error, you can always white it out or do a new form, but do not put any false information on here, okay? Next. The civil summons. Now, this is one of the most important documents when you are filing a new lawsuit. This is AOC CV 100. this is legally under our rules of civil procedure, our general statutes. This is the document that starts the lawsuit, and it's used to serve the defendant. I'm going to go to the next slide that will have a screenshot of the form, but you want to make sure that, this is kind of walking through how to fill that form out. Under state of North Carolina, you want to put the county's name where you plan to file. So if you want to file in Guilford County, you put Guilford. Like I mentioned before, all custody actions, all family law matters in North Carolina are heard in district court. So you want to check box district court, not superior. You will be the plaintiff since you are the one filing the lawsuit. So you put your name and address under plaintiff. Then you want to write your co-parent's name under defendant because they're the other party of the lawsuit. And then it's going to seem redundant, but where it says to each of the defendants below, you want to write that co-parent, that defendant's name and address there. So you're going to have to double, write their name twice, but you want to make sure their address is included. Now, if they have an alternate address, you think they might be difficult to find, I always say put their home address, their last known residence that you know of, and maybe a work address that, or, if they stay with their parents on the weekends or whatever that may be, and they're going to be there, I would put that. But you really want to make sure you put their last known address in the two box to each defendant below. In the box that says name and address of plaintiff's attorney, if none, address of plaintiff. So you put your name and address. Like I said before, original and 3 photocopies, or you can do 4 originals. And then here's another, I have this asterisk here for 2 yellow and 2 white. What that means is prior to e-courts going live throughout the entire state, some county clerks require that the summons, they only have 1 white and 3 yellow, 2 white, 2 yellow. If you don't have yellow paper, you can write for service at the top of 1 copy. Typically, a yellow is for the defendant, the original is for the clerk, and the white copies are your copy. And then if you serve by sheriff, then you want an extra yellow copy. So I say check with your county clerk, because with e-courts now, a lot of them don't require yellow paper. So that might not be something to stress about. So just keep that in mind, check with them. And also, you can check the local rules for your county. You just want to go to nccourts.gov and then search for your county. If you're in Durham County, go to Durham and then go down to the Durham County Courthouse page and go to local rules and forms, and that will have more information if there's a specific requirement for yellow paper or not yellow paper. And if you have a question, just call your clerk's office. They're wonderful and helpful to answer questions. This is what the summons looks like. So the top half is the part that you fill out, and then the bottom left where it says name and address of plaintiff's attorney, if none, address of plaintiff. That's what you fill out. The bottom right hand side where you see all the smaller boxes like date issued, time, signature, all of that, that's filled out by the clerk of court, the deputy clerk of court, assistant clerk of court, or the elected clerk of superior court. So you leave that blank, but you fill everything else out. And then once you file your lawsuit, at the very top, you'll see file number with that sideways triangle on the top right. They will assign a file number for your lawsuit. And that's going to be really important to keep that in mind, to know what that number is, because that's the way the court system will identify your filing, your lawsuit. Okay, the complaint. So this is going to be in your pro se packet, your file it yourself packet. And it's designed to be self-explanatory. I often say don't leave any blank spaces unless you are sure it does not apply to you. One section I'll mention, it talks about each child what I mentioned earlier, list where they've lived for the past 5 years. If you have one child, you don't need to put anything for a second child. But you want to make sure when you are filling it out for custody or visitation or both, you want to be as detailed as possible. You want to provide the court, the judge who will be reading this document, the most information that is relevant and applicable to make a decision on custody and visitation. It has to be notarized. So this one is, again, you will need to take it to a notary public. With a notary, that's one of those things where, you want to make sure that you have a notary. If you don't know where to find one, I often say if you have a bank account with a credit union or a bank, they usually have notaries. You might need to make an appointment or you go and wait, but you can usually go there for a notary free of charge. Sometimes you can go to, I think it's a UPS store. They do charge for notaries. But usually your financial institution, if you have a bank account somewhere, they can notarize. You'll need a photo ID. Okay. You want to have an original and 3 photocopies after you have the verification page notarized. You want to fill in the county where you live, your name as the plaintiff, and the defendant's name. And this is where I'm going to say a general rule of thumb. If you have a very common first and or last name, I would say use your middle name or middle initial as well. If you go by your middle name, that's something I would say. If you go by a nickname, a good rule of thumb is using how your name is listed on your driver's license or your photo ID or your passport, whatever form of identification you're going to show a notary, put your name how it's listed on there. So let's go through the actual complaint and talk about all the different boxes, okay? So number 1, you want to fill out the county where you live, and number 2, where the county and state where the defendant lives. Now, if they're in North Carolina, great, still put it. If you live in, I think the earlier example was like if you live in Durham and the other person lives in Wake County, put where they reside. Then number 3, you want to put what is the relationship you have with the defendant. Are you married but living separate and apart, meaning you're legally separated? Are you divorced from the other parent? And the other option is you're not married. You never were married. So just checkbox the correct applicable option for you. Now, number 4, you want to put in the full legal names of all the children involved in the case. You want to include their current age and date of birth, and I say location of birth. Where were they born? And that doesn't have to be like the name of the hospital. It can be city and state. That's enough. If they were born in Greensboro, North Carolina, you put that. If they were born in Washington, D.C., you put that. Okay, let's keep going. For number 5, now this is that section where I mentioned if you don't have more than one child, it's okay to leave the other sections blank. Number 5 talks about for each child, you have to fill this out. Where they have lived for the past 5 years, including the address of where they lived, the name of the individuals who the child lived with, and the current address of those people the child lived with. Now, you want to put in the time frames as well. So this might be something you can work on before filling out the forms, is coming up with like a timeline. So if we're at January 13, 2026, we're going back to January 13th of 2021 to present. And kind of work your way. I like to go backwards. So I'll look at, okay, where does the child live now? And before then, where did we live? Okay, we moved in 2023. Okay, work backwards like that and make sure you put a month and a year. they don't need an actual date, but knowing the month and year is really important to include that. Now, this is really important also to be truthful. If the child has lived with both parents equally over this course of time, you put that. Remember, you want to make sure that you're being completely truthful, because you are going to have to swear or affirm to a notary that all the information you put in this document is true information. There's nothing false. Okay? Okay, let's say you fill out the boxes, the chart, then you're going to have to put, check mark 3 additional questions. First is, has there been any litigation or other lawsuits concerning the custody of the child in first child box? That's going to be the same for every child. You're going to have to answer the questions that you have participated in litigation concerning the custody of the child. If you haven't, don't check it. You have information of a lawsuit concerning the above named child in North Carolina or another state. Again, if you don't, leave it blank. If you do, let's say you do for this question or the first question, you will have to list the name of the court. So that could be like, if it were in North Carolina, you could say Durham County, North Carolina District Court. You have to put that case number, that file number that identifies your filing, and then the date of a decision, the date a judge entered an order. If any of those are applicable, you have to fill that out. If not, skip and go to the next question, okay? Next question is, I know of a person listed below, so it gives you some lines to fill that out, if they have current or a claim of physical custody. Also, if they are claiming visitation rights, you can check mark that, but you have to list the name and address of those people if that does exist. If not, put an NA, not applicable, and move right along. Okay? They have space for up to 2 children. So if you need additional space, use additional paper. Okay? But make sure you include the same information for each child. Question number 6, this is saying that you are a fit and proper person. It kind of sounds weird, but those are legal terms that you have to include. You're a fit and proper person to have custody of the child. It's in the child's best interest that the plaintiff that you have or be awarded, you want to check mark custody or visitation or both. I would say at all, to encompass all the things, I would check both. And then that just shows the judge that you want custody and you're okay with some visitation, or you just want to put custody, and that's what you're asking for. Number 7 doesn't have any fill in the blank. It's just a statement that you need to include for a custody claim. And number 8. Now, number 8, this is the appropriate box for that jurisdiction that I mentioned earlier, that has the child lived in North Carolina for 6 months? What is their home state? And you'll hear that term, home state. And so this is where you will check the box that either they've lived in North Carolina for 6 months prior to filing the lawsuit, or they're under 6 months old and they have lived in North Carolina for the entirety of their life. Okay, now we're going to get to the prayer for relief. What does that mean? Well, this is the section where you've made all your allegations to the judge, and now you are praying for the relief. You are asking the court to make a decision. Based on all the allegations, all the information you have included, you're asking the court to make a decision. Now, number 1 under this wherefore section says, for an order giving plaintiff, these are the options: temporary and permanent custody, or option 2, temporary and permanent visitation of the child or children listed above. So those are your two options, temporary and permanent custody or temporary and permanent visitation. Again, I would say those terms are interchangeable. Just remember, visitation is often viewed as secondary physical custody, and regular primary custody is often just labeled as custody. So just keep that in mind as you're filling this out. And then I'm going to say at the bottom, it has a place for you to put the date, and then for you to sign and print your name and put your contact information. Your name, you want to print and sign. You're going to put your phone number. You want to put your mailing address. That's really important, because a lot of ways the court will communicate with you is through mail. And also, there's not a spot for it, but I'm going to recommend you put in an email address if you have one. If you have an email address, it's really important that you put it on there if you are comfortable using email and receiving court communications through email, or automated communications from the court system. If you do not feel comfortable using email or don't regularly check it, don't put it. And then at the end of this document is what we call the verification. This is the section that notary will complete. They are going to look at your photo ID. So if you have a government issued ID, an identification card, if you have a driver's license or a passport, this is what you use to show the notary to confirm you are who you say you are. And then once you get to the notary, that is when you sign it. So do not sign until you are in front of the notary. And then the notary will fill out the verification page. They'll put in where where they are located when you're going to sign. They'll fill out your legal name. They will fill out their notary information, and then they will put their notary seal on it. Okay. Now I went through the form, and so this is what the complaint looks like. You can see for number 5 where I mentioned the box for first child, second child, and again, if you have more than 2 children, you want to fill these sections out for however many how many children, excuse me. Okay. Here's just going into number 6 where I mentioned you want to select custody and or visitation. And then you see this is the wherefore the plaintiff praise of the court. This is that prayer for relief. This is where you have put all this information in 1 through 8, and now you are asking the court to do something with that information you've provided. So just make sure you fill that part out. And then you'll see at the bottom, it says plaintiff signature. Do not sign that until you're in front of a notary. Here at the top, you see the contact information, the phone number, mailing address, and then you'll see this next section where it starts state of North Carolina, county of blank, and then verification. This is the spot where the notary will complete it. They'll look at your photo ID and they will make sure you are who you say you are. They'll have you sign this and the previous page. And then at the bottom, they will fill out their notary information, the day they notarize your signature. They will sign it. They will print their name. And then when their notary commission expiration date is, and then you'll see official seal. That's where they'll put their little stamp on the document. Okay, I mentioned affidavit as to status of the minor child. Now, this is, again, it's an affidavit. It is a sworn statement that you are providing to the court. So everything on this document must be true. Also, this is a form that must be notarized. Since it is a sworn statement and affidavit, it must be notarized. So this is that form where I mentioned you'll need one for each child of this family, of the children that are shared between the 2 parties. in this lawsuit. And one thing I just want to mention, this says affidavit as to the status of minor child. Custody action is only for children under 18. So if you have a child who is 19, still living with you, but, works or is going to school, they are a legal adult as far as the court cares. You can't do a custody action for a child who is over 18. So just keep that in mind as well. Remember AOC CV 609, and now let's look at what that form looks like, the affidavit. Okay, so remember I mentioned your file number, court file number is how they will identify or locate your file in the court system. So when you're doing this initial filing, you won't have that to fill in, but once you file, the clerk will fill in the court file number once they assign one. You want to put in your county where you're filing, the name and address of plaintiff and defendant, and this is, the timeline. I call it a timeline. For the past 5 years, where has this minor child lived? And it's a time frame. Remember the period of residence, the address, who they lived with, and the present address of that person. So if they lived in the home with a sibling who's under 18, you can just say minor siblings. If they lived with an adult sibling, you can put that adult sibling's name. Whatever is easier. If you need more space, you can always add more pages. And then you want to fill this out as complete as possible. Oh, and then let me go back. This bottom section where it says sworn/affirmed and subscribe to before me, that is the notary section. So everything above that line you need to fill out, and everything below the notary will fill out when you sign. Okay, domestic civil action cover sheet. Now this is the one where I said some counties aren't requiring it anymore. Some still do. I always say, call the clerk, ask them if they want it for paper filings, fill it out, original and 3 copies. I always say 3 copies because the court will keep the original. 1 is for the defendant, and then you want to keep 1 copy for you. And then when you have to serve the defendant, if you have to try multiple methods, you have an extra copy as a backup. And this is what the form looks like. The top part we've talked about, kind of it's similar to the summons, how to fill that part out. You want to put in the name and address of plaintiff yourself versus defendant. There would be 1 defendant here. Summons submitted, you want to say yes, because we talked about how we're going to file the summons. And then you want to put on the top right hand corner, it says name and address of attorney of party, if not represented, complete for the initial appearance or change of address. So you want to put your information if you are not represented by an attorney in that section. Also, if you have a fax number, if you want to put your cell phone, put it there. They also, I think on an update, once you pull this on the forms website from nccourts.gov, the updated one will have a spot for your email address. So if you have an email address, you want to put that. This has a spot for attorney email, and you can put it here as well. So type of pleading, you want to put complaint. That's the name of the document we just went through. And then on the bottom right hand side, you want to check box the custody. Let me see, that's like the 4th box down. CUST is the court abbreviation. If you are doing just visitation and you're not asking for custody, at the very bottom it says other. Right above it, it has visitation, VIST. So you want to pick one or the other or both if you select both. Okay, we have a sip of water. Okay, I mentioned briefly custody mediation under our North Carolina general statutes. In North Carolina, it is required with any new custody lawsuit and initial filing or a motion to modify custody, a prior court order, it is required to go to custody mediation. If you have not not gone to mediation through the custody mediation program before, you will have to go to orientation for mediation. Now, these cover sheets are very specific to your county. You want to check, I mentioned this, the local rules and forms page on your county's website on nccourts.gov to find the specific forms they require for custody cases and any additional requirements. For example, I know some counties require a parenting class. I think one in Guilford County is called Two Homes Now. Parenting under two roofs, different things like that. Oftentimes I even have clients who ask, why do I have to go to a parenting class? And then they come back and I thought I was a great parent and I learned some things here. So don't see parenting class requirements as a hindrance. It can always help. But some counties require it. So always check that local rules and forms page on your county's website on nccourts.gov to make sure you're doing all that is required in that county. It's that cover sheet is used by the custody mediation office to schedule your orientation and mediation dates. It's required that you attempt at least one session of mediation. And on this form, typically, now I'm going to show you an example in the next slide, but typically what they ask for: your name, address, date of birth, phone, and email. For the plaintiff, same for the defendant. It will ask if you were ever married. If you were, they'll ask for your date of marriage and date of separation if you have one. And then they're going to ask the name, age, and date of birth of anyone who resides with a child and their relationship to you. So if you have a new partner, if there's an adult child living with you and your child, that's the kind of information you'll need to put. And again, like I said, these vary from county to county. So it's really important to familiarize yourself with your county's website on nccourts.gov. And so here's an example from, excuse me, Robeson County. It shows, contact information. If you have an attorney, you'll have to put your attorney's information, and then your children. And then you have to sign and date it. And then at the top, you'll see file number. And at this point, you've prepared this and you don't have a file number. Once you get the file number, you fill it in, or if your clerk's office will fill that in for you, they will put the number they assign to your case. Okay. Your Service Members Civil Relief Act, the SCRA for short. This is the federal law that all states adopt that protects a service member's legal rights during active duty. When a service member on active duty is sued with any civil lawsuit, so custody, non-family law, any civil lawsuit, this declaration has to be in the court file, and it is required for every lawsuit. So if you know someone is a member of the Army, Navy, Air Force, Marine Corps, National Guard on active duty, this is extra important to make sure you put that information on here. There is a form, the Administrative Office of the Courts, I call it AOC. They developed this form. I mentioned it earlier, AOC G250, that you fill out and it will comply with this federal law. And it also asks you to search a federal website, a database, to determine if that opposing party, if the defendant, your co-parent, is an active service member. And so again, we put the link here, but it's in the nccourts.gov form/documents. And then the link at the bottom, it's also on the form, but it's a link to the federal government's website to check the database. And in order to check the database, you'll need the person who you're searching. You'll need their date of birth, full legal name, date of birth, and if you have their social security number, you can search it with that. But full legal name and date of birth usually will be enough. If they are on active duty and you know they're on active duty, the court, a judge in North Carolina, will not, because they cannot enter an order until until they appoint an attorney to represent them. If they're on active duty, most often what I see, the court will put the case on hold, stay the case, or postpone it until they return from active duty, until a different date. This is a protection that orders aren't entered against service members when they are not physically present because of their military duties. If you are filing a new lawsuit in North Carolina, you want to always complete this declaration when you start your lawsuit, when you initiate your legal action. In the area of divorce, I see that divorces are regularly denied or continued to a later date if the declaration is not filed. And I can see the same happening with a custody case without a doubt. This is what the form looks like. It used to be an affidavit where you have to have it notarized. Now it's no longer required to be an affidavit, but you can see you at the top, you'll see most of these court documents, the top section is pretty much the same. You want to put the name and address of each party. You want to put the county, and then at the top right corner is always going to be that sideways triangle with file number. And also you want to make sure you just read the forms. A lot of the times they look really intimidating and a lot of words, and then there's this big space. They usually like these notes and they reference statutes, and it's really explanatory. It explains a lot, but this one says you have personal knowledge that the defendant is in the military service, not in the military service, or you are unable to determine if they're in the military service. And then if you have a copy of a military order from the defendant relating to active duty, North Carolina National Guard, or any other state active duty, you can include that. If you use the Service Member Civil Relief Act website, that database I mentioned, you mark if you did or did not use that database. And then if you do use the database, what it will do as your result, it will give you a PDF, and it will say it searched all these databases, and for each one it will list if the defendant's name with that date of birth was found as someone on active duty. If you have not searched that database, number 4 is where you want to put all the information of how you know the defendant is or is not in the military, and you want to be as specific as possible. I've known the defendant since I was 14, and at no time since that age have I known the defendant to be in the military service, or I know the defendant joined the North Carolina National Guard on January 1st, 2002, and they are an active service. All of that information is best and as specific as you can, you put in that space under number 4. And then at the bottom, you date and sign and print your name as well. Okay, So we've gone through all these documents and you're ready to file. What now? Okay. As I mentioned, you want original and 3 copies of each document. The original is for the court, 1 copy you're serving the defendant, and 2 copies for you. And again, 2 copies for you, one for your personal copy, and the second backup copy is if you have to serve the defendant in a different manner. And we'll talk about that once we get to that section. You have to pay the court filing fee, or you ask for the clerk to approve to grant your petition to sue as an indigent. As I mentioned, the court filing fee is $150 for all civil actions except absolute divorce. You want to ask that the copies of the summons be issued, and that's just the legal word, issued meaning start the lawsuit. If you are going to serve the defendant by sheriff, the sheriff's fee you should have ready with you as well, and that is $30. The clerk will issue the summons, and then what I say, file stamp, literally stamp all the copies of your documents. They will put the file number. Every page you saw in the top right corner will have your court file number. That's kind of like your ID number for the lawsuit. And it will take some time. So I always say plan about 30 minutes, maybe to an hour, depending on the time of day you go. I'll say first thing in the morning, the clerk's office is busy around lunchtime. So most clerk's offices have like staggered lunches, but the court lunch break is typically 12:30 to 2 p.m. It's usually busy around that time. Around 2 o'clock, it gets busy. And then at the very end of the day, it gets pretty busy. So just plan at least 30 minutes, 30 to 45 minutes minimum when you go to get all your documents filed. And one thing I'll say, I haven't mentioned, how do you find where you're filing these documents? Well, it's going to go back to your county's website on nccourts.gov. Once you look up, I've been saying Durham County a lot. So if you're going to Durham County Courthouse, you go to the website for Durham County on nccourts.gov. It will have, most of them have a picture of the courthouse, which I love. I'm very visual. I like to see where I'm going. It'll have an address. It'll have a phone number. It'll have actually a lot of them have directories. So if you need to call the family court, or if they don't have family court and it's just civil, you call the civil clerks. They'll have phone numbers. It'll have instructions. Some will have like parking instructions. So always check on there where your courthouse is, what's the address, and if you need to call that, they're very happy to help people figure out where they need to go and what they need to do. Okay, how are you going to pay your court costs? Let's say you didn't sue as an indigent or it got denied. The clerk's office does not accept personal checks. They will accept cash, of course, money orders, certified bank checks. They will take business checks, like from a law firm. So those are your options, but I believe some take credit card, but again, there are fees associated with that. But to be on the safe side, either take cash or a money order. I always tell people a money order is great because you have a paper trail, and that's always helpful to have that record. And also remember, clerks of court, they may be lawyers. A lot of them are not licensed attorneys, so they cannot give you legal advice. If they try to give you legal advice or you ask them for legal advice, they should be telling you, I'm not a licensed attorney in North Carolina, and you need to talk to an attorney. And they might say, here's the lawyer referral service. Here's the information. They can provide that to you. They can help you get the resources or contacts, but they cannot give you legal advice like how to fill out the forms or what's your next step after I file this. They cannot give you that information. So just be mindful of that. Okay. Serving the defendant. Now, these are some options to serve the lawsuit. Now, this is only for the initial lawsuit. All later documents you file with the court, you can serve just through USPS, regular mail. But here are some options. Sheriff, or if you want to pay for a process server, they're more expensive, often than your county sheriff. You can do certified mail return receipt requested, or another mail delivery service with a signature requirement. So FedEx, UPS, DHL for international locations. And then a third option is publication. And publication is what you often hear about. I'm putting this legal notice in the newspaper. They're going to see it in the newspaper. We'll talk about when and if and when that is appropriate. You cannot serve the defendant yourself. You can't just go to your co-parent's house and hand them this paper. That's not allowed under North Carolina law. I mean, you can do it, but you still have to serve them by one of the approved methods under our North Carolina law. Okay. And your case cannot move forward without service on the defendant. And the court file has to have proof of service. And so we're going to talk about each of these steps and how to put service in or proof in the court file. Now, sheriff, I mentioned this earlier. It's $30. Again, cash or money order are your best options. And then the sheriff's department where the defendant lives. So in that first example we used of you live in Durham County, defendant lives in Wake County, you would have to take your papers, the file stamp complaint, summons, SCRA declaration, affidavit of status of minor child, and the custody mediation paper. All of those, you have to take a file stamp copy to that Wake County Sheriff's Department. And what it's called is the Civil Process Department. You can always ask whenever you go to the Sheriff's Department at the first window, just ask, I need to serve a lawsuit, a civil lawsuit. You give them all those papers, and then you pay the $30, and then they will have that go to a sheriff's deputy to attempt service on the defendant. And how do they know where to go? The summons. Remember how I mentioned the address on the summons is really important? That's how the sheriff is going to know where to go to serve these papers. Now, if they do achieve service, meaning they were able to find the defendant and hand them the papers, then that second copy of that summons will be filled out on the back by the sheriff's deputy, and it will be returned to the Durham County Clerk's office where you originated the lawsuit. If you want to call and check the sheriff's department, if it's been served yet, I would say give them at least a week. If it's a weekend in between, give them a little more time. I say 5 to 7 business days is a good time frame to give them the opportunity to serve them before you check. If they live outside of the state of North Carolina, the defendant, you want to call that city or county's law enforcement office and ask for their service of process procedures and what does it cost. For example, Virginia, they have a different fee for sheriff service from out of state or in state. I think it's $75. South Carolina, I think it's like $25. So it varies. It varies from different states. Florida has a different cost. So you just need to contact that local city or county sheriff department outside of North Carolina. But everywhere in North Carolina is $30 per defendant. Now, certified mail. I always say for custody, sheriff is your best option for option number 1. Let's say the sheriff has gone out to the defendant's address 4 times, unable to serve, and they return it to the clerk's office saying unable to serve. What do you do next? Well, I have it this time. You want to serve them by certified mail. It's going to be this green and white card that says U.S. Postal Service certified mail certified mail receipt, official use, and then you're going to have the return receipt. It's a green card that you stick on the back of the envelope. This right now is about a little less than $11 to do this. What you need to achieve is the defendant has to sign on this card, and then they will date it, and that's the day you know they've been served. When you do file this with the court, well, let me take a step back. When you serve this, you want to put this in an envelope. You want to fill this out at the post office. I keep some in my law office. And then you go to the post office, you pay the postage and the certified mail fee, the return receipt fee, all of that. I think I just did it yesterday, was $10.44. You pay that, and then it will give you a tracking number. So there's like a little tracking number right here. And so you can go on USPS tracking and search, where is this piece of mail? Has it been delivered? Have they attempted? Has it been picked up? You can check that status. Now, when you get this green card back in the mail saying it's been received, you need to make sure they've signed for it. And then when you file your proof, or how are you going to file your proof to the court? In your court file that you serve the defendant by certified mail. This is going to be in your file it yourself packet, and this is your affidavit of service, your affidavit of return of service by certified mail. This is just a screenshot of what that document looks like. You want to fill out the top like we talked about, county, you'll have your file number now, so you fill that out. You want to say I would say Manisha, the plaintiff in this action for custody being first duly sworn and deposed, and say and certify that. This document is an affidavit, so it is a sworn statement that has to be signed by, or excuse me, has to be notarized. So again, you fill this out, but you do not sign it until you're in front of a notary. Okay. What I often say is, you need to provide the green card that comes back to you in the mail, but I think it's a good practice that you get the tracking history from the USPS website, the post office website. You print it out. You either you tape this green card on there, or staple it. I think that most clerks like the tape. It's easier to scan now. But this is your proof. This is your proof that you've sworn in front of a notary that you mailed it to the defendant, and you put what address you mailed it to, and that the date, what date did the defendant receive it? And that's going to be evidenced. You're going to get that information on the return receipt. This light green card that comes back to you, it'll have their signature, their printed name, and the date of delivery. And so that's the date you put on here. Okay, what next? The defendant has 30 days to answer. In those 30 days, they have some options. The defendant can do nothing. They can make a motion for an extension of time, which is an additional 30 days to respond to your complaint. Or 3, they can file an answer of response with or without counterclaims. This is like a big, like alert sign, antenna goes up. If there are counterclaims other than custody and visitation that the defendant has filed, contact an attorney. I would want you to consult with an attorney to help you understand what are they asking for other than what I'm asking for. I know they can ask for custody just like I am, but are they asking for child support? Are they asking for something else? What are they asking for? So those are the 3 options that a defendant has within the first 30 days. After that 30 days expires, let's say they did not get an extension of time and they did nothing. Okay, what now? The case will be set for mediation. Now, what happens is the custody mediation office, and again, like I said, mediation offices vary by county, but most often, once they have that mediation cover sheet, they will make sure that you are signed up for mediation orientation. A lot of counties after COVID have done an online program if you physically can't get to the courthouse, but typically they're held at the courthouse, and then they will make sure that you've hit all the other requirements in the county. So like I mentioned, some have a parenting class requirement. They will make sure you have completed that. And then they will give you and the defendant instructions of what to do next for mediation. Okay, so mediation, what is this? This is a process where a neutral, I call a neutral, a third party neutral, help you and your co-parent develop an agreement. I call it a parenting plan, parenting agreement. They're different terms, they all mean the same thing. It's an agreement that you and your co-parent have come up with to care for your children during and after separation, whether you have a plan and you want a mediator to help you iron out the kinks, or you have a general idea of what you want, but they're like maybe a few nuances that you guys need help with. A mediator's goal is to help you have an informal forum, a very informal proceeding to help you discuss the parenting, co-parenting issues or disagreements you have and help you come to an agreement. This is typically your first step before you go to a trial. And when I say a trial, I mean a custody trial in front of a judge in open court. There could be other members of the public in the courtroom gallery while you're having your trial. There could be no one, but that is like your last step going to trial. So how does mediation work for custody? You have your orientation session followed by a mediation session. You're required to attempt at least one. So what is that? It's an informal confidential meeting with you, your co-parent, and the mediator. And the only documentation that leaves this session is the parenting agreement if you reach one. No attorneys are allowed, even if your co-parent has an attorney or you have an attorney or you've talked to an attorney to help coach you for mediation. It's just you and your co-parent. The child or children are not there. It's just the two of you, typically, most commonly in person. But I know, again, post-COVID, a lot of people have opted for WebEx mediation or telephone mediation. So again, check with your court, your custody mediation office to see what their specific options are. So mediation, what do you do there? Well, you can talk about common schedules. If you don't have an idea of what schedule will work, here are some common visitation schedules. A 2-2-3 is also called a 5-2 schedule. It can be, Monday, Tuesday with mom, Wednesday, Thursday with dad, Friday, Saturday, Sunday, you alternate. It could be every other weekend. You can alternate major holidays. I listed some here, and then spring break, summer vacation if they are not on a year-round school system. An option I find that's really great for older children, like high school age or even middle school age, is a week on, week off schedule. A mediator can suggest what you should consider, but they don't make a decision. The two parties, the parents, make the ultimate decisions. And so these are just ideas. One helpful tip I give is if your children or child are school age, get the academic calendar for the county school system or that school they are enrolled in. Get the academic calendar so you know, does this school have a lot of teacher work days? Do they have a lot of Mondays that are teacher work days, or Monday holidays that are not these major holidays? What does the school break look like? The summer break? What does spring break look like? Is it the same weekend as Easter? That also will help you kind of guide these major holidays or school breaks to give you ideas of how to share that time, or so you're just prepared. You're not blindsided if your co-parent brings up some holidays and you haven't thought about it. Now, what do you do if mediation is unsuccessful? all is not lost. And I don't like this term. Some people say you failed at mediation. It's not a failure. You attempted it. You tried it. It just did not result in an agreement. So what do you do now? There are a few things you can do to prepare. Ask the clerk who's in charge of setting hearings. So I always say the calendar clerk at your judge's chambers office to give you a hearing date and follow the directions they provide you. This is where you will have to file a notice of hearing. Some people call it a civil calendar request. Different counties, judicial districts call it different forms. Sorry for that typo. So check your county's local rules and forms page on nzcourts.gov. The notice of hearing filing fee is $20 in North Carolina. So make sure that you have that when you go to file it with the clerk where you filed the initial lawsuit. And that note, that $20 is all in North Carolina. So regardless of which county you're in, it's going to be $20. You want to serve the defendant with filed copies of both forms. I mean, sometimes they're one form, sometimes they're two forms. Whatever your county does, follow those instructions and those forms. And then you want to keep track of all the dates and be on time. You want to, if it's easy for you to create a calendar, I color code a calendar on my phone. I have a desk calendar at home. I have a wall calendar. For me, like I said, I'm visual. I need to see the differentiation of when I have court, when I have another meeting, whatever that looks like for you, whatever system works for you. Keep that going for this, and then be on time for court. And being on time means being early. When they say court's at 9 o'clock, that means the judge will sit on the bench at 9 o'clock, call the bailiff will call the courtroom to order, and the judge, you stand up, the judge comes in. So if court starts at 9 o'clock, get there at 8:45, 8:50. You're gonna have to go through security. Prepare for that. You're going to have to walk from a parking deck. You're going to have to lock your phone in the car. So just make sure you are familiarize yourself with your courthouse's rules, you know, how long it takes you, where you need to park, all of that. And then this is where on that self-evaluation slide at the very beginning, we talked about what evidence are you going to present? This is the time you need to gather that evidence. So whether they're witnesses that can testify to your ability to care for your child, they've seen you as a mom or a dad, they've seen you as being a good parent, you know, that's, I don't like to say that, being involved in your child's life. Any evidence that supports your claim, what you're asking the court for. If you're asking the court for custody, you want to show them pictures of the child's bedroom to say that, look, their physical well-being is being satisfied here. They have a clean space, they have their own bed, they share a bathroom with their siblings, this is our breakfast table, this is where, you know, little Susie helps me, you know, cook when she has her own little like child safe knife set, you know. So you want to show that evidence of why you're providing the best home for your child or your children. And then this might be a really good time to have a consultation with an attorney. Oftentimes people think they don't need an attorney or they can't go past this point without an attorney. You can. It just might be helpful to talk to an attorney prior to a trial to make sure you're heading on the right path about your witnesses, the evidence, all the things that you want to use at trial and present to a judge. So even if you choose not to hire an attorney for a trial, this might just be a good time to talk to an attorney and just make sure you're on the right path. And they might know some nuances, some unspoken rules or practices of your courthouse to help you. Here's what this calendar request notice of hearing looks like for Alamance County. Again, this is just an example that you can download from Alamance County's website on nccourts.gov on their local rules and forms page. So this is just an example, but I've experienced many counties have a different form like this, and it's very specific to that county. So just make sure you check there. And then call or ask the calendar clerk when you go to the courthouse to file your paperwork. Before the hearing. Now, if you want to stop your claim for custody, you can always file a notice of voluntary dismissal without prejudice. Okay. This voluntary dismissal, what does that do? It stops the entire lawsuit. It will, you can pick it up for up to 1 year, but it's a last resort option. Preparing for trial. You want to dress conservatively and professional attire. Now, this doesn't mean go to Belk or Macy's and go get a brand new suit. Just you want to dress and put your best presentation forward. How would you dress if you were going for a job interview? How would you dress when you go to church on a Sunday or whatever day you go? Just want to keep yourself together, have your hair combed, be on time like I mentioned. This is so important, and people can tell. No drugs or alcohol before or during court. Okay, a judge will be able to tell, a sheriff's deputy will be able to tell, anyone in the courtroom will be able to tell if you are under the influence of some substance. So just don't do it. Okay. Always tell the truth and maintain your temper and composure. Cool, calm, and collected. And I always say, if you're getting heated, someone else is testifying and you're like, it's not true, they're just lying. I always say, make sure you have a notepad, take your notes, but keep yourself composed, because the judge is not only listening to what the witness is saying, but they are observing every single person in the courtroom. They're going to be looking at you. They're going to look at the other party. They're going to look at the witness, any attorneys. They're going to look at your support people who have come to court and sitting in the gallery. They're going to observe and take into account what they're seeing from everyone. And then when you are testifying, you want to speak clearly, stay calm, and you want to talk to the judge. And I get really nervous when I have to, talk, or I have questions being asked of me. So my rule of thumb is I'm going to use everything, act like everything is a conversation. You are having a conversation with the judge. If the judge is asking you a question, you give them eye contact, and then you're having a conversation. No juries are used in custody cases, and the judge will always determine the facts. Finally, and you've probably seen me do this a couple times, remember to breathe. When my mind goes faster than my mouth sometimes, and I talk very fast, sometimes I have to just stop, take a breath, get some oxygen to my brain, and then keep going. So just remember to breathe, and no one's going to fault you for taking a breath or taking stopping for a pause. After the hearing, the judge will make a decision either verbally in court, or they'll say, I'm going to write it out, and then the order will be mailed to you. That decision is called the order. You have to comply with this order as it's written, regardless of how you feel about it. Remember, they can give you an order that you don't agree with, but you're stuck with. If you violate the order, they can punish you for failure to follow that order. That's called contempt. We're not going to go into that here, but just keep that in mind. Modification of orders. This legal standard for modifying orders is different. If it's a temporary order, for a permanent order, you need to show best interest. If you have a permanent order, you have to meet two standards. First, that there has been a substantial change in circumstances affecting the welfare of the minor child since the prior order. And two, the modification you're requesting is in the best interest of the child. You can't get to number two until you meet part one. So that's just something to keep in mind about permanent custody orders. COVID in the court, there have been, various operations, times change, hours of operation. Some hearings and mediations are conducted remotely, very county specific. So check their local rules, or call your local clerk of court's office to get that information. I don't think there are any courthouses requiring masks, but just to keep yourself and everyone else safe. If you've been sick, traveled internationally, you have a fever, especially if you have a fever, exposed to COVID, diagnosed with COVID, or in close contact, don't go to the court. Call the clerk's office and let them know. If you have court that day, when you call, let them know you have court and they will notify. Oftentimes they need to have some sort of doctor's note. And if you are just under the weather and coming to the courthouse, maintain social distancing. Court closures, hopefully, knock on wood, we won't have some inclement weather this year, but if you do, the judicial branch website, which is at nccourts.gov, and their Facebook page will have links for court closures and delays. Finally, good luck. Here is contact information for the legal aid helpline, legal aid website. I mentioned the North Carolina Lawyer Referral Service. It's a service of the North Carolina Bar Association. And so I would recommend, if you are seeking that option, go to the website, and they have a self-serve form you can fill out, or you can call for a discounted consultation, 30 minutes for $50. But with that, that's the presentation. I've spoken for a very long time. Hopefully I've answered a lot of the questions that have come in. But Marissa, are there any that I haven't hit?
Someone's asking, how come it takes so long to get court hearings when someone's in contempt of court?
I think that one is dependent on wherever whichever court system you're in, whichever county. I know in some counties, it can be heard within a couple of weeks. Some will have continuances until the other party is served by sheriff or one of those other ways. But I think, unfortunately, I can't give you an exact answer why things get delayed or why it takes so long. I do think that there has been an influx of filings in our district courts for family law matters. So just as the years go by, more and more matters are being filed. So it just unfortunately takes longer.
No worries there. Um, get a couple, quite a few questions here asking about counties in which, like, say, originally the action was filed in one county, but now neither parent lives there, or can we get something moved to it, get the filing, the case, Lord have mercy, moved to another county? So can you just talk about within North Carolina changing
Okay,
venue?
yeah, absolutely. Within North Carolina. So let's go back to our example of Durham and Wake County. Let's say the action was filed in Durham County. Mom and child live in Durham. Dad lives in Wake County. And then 3 years down the road, kid is in high school and everyone moves to Mecklenburg County. Well, if no one lives in Durham County anymore, what your option is going to be a motion to change venue. Now, venue is that word, not jurisdiction here. We're talking about venue. Venue means location. Where's the location of this lawsuit? So the venue would be proper to move to Mecklenburg County. And I say Mecklenburg, that's where Charlotte is. So you would have to file in the originating county in Durham a motion to transfer venue is what it's called. And then that would have to be heard by a judge. A judge would issue an order. And once that happens, that the clerk's office in Durham County would send it to Mecklenburg County clerk, and they would create a file, a new file number, an action in Mecklenburg that will take essentially that whole file out of Durham County to Mecklenburg County.
Okay. Mm. And then just to confirm, I don't know if you had, you just went over this, but where should it be filed? Is it in any place the plaintiff or defendant is, or does it have to be in the county where the child resides?
My general advice and preference would be where the child lives, but the proper venue, so remember, venue location is going to be anywhere where either parent lives, parent A, parent B, or the child if it's in 3 different locations.
Gotcha. Again, we will have a hard stop at 4:30, so I'm trying to get to the questions that weren't answered in your presentation more so. Oh, okay. Someone is filing, I guess, to intervene into a custody case.
Okay.
Um, and they're just, I guess, a grandparent has filed for custody. Who is responsible for starting the mediation process? Would it be one of the, original plaintiff and defender, or does the intervener become responsible for that?
The intervener, so they're not an intervener unless the a judge allows them to be. So they're just a movement into the lawsuit. And so until a judge allows them to intervene, they're not a party to the lawsuit. They're trying to become a party to the lawsuit. So if there's a motion to intervene pending, the custody mediation office will not move forward with mediation until there's a determination on that motion. So let's say that motion is granted, then there would be a mediation between parent A, plaintiff, plaintiff parent, defendant parent, and intervener grandparent. So they will wait. And so let's say something happened with the intervening the motion, the judge grants it, then if you're trying to get this moving, I would recommend you contact the clerk's office and the mediation office and let them know that we're ready to get this scheduled.
Gotcha. A couple people are asking about service if the other party is abroad or the defendant is actively avoiding service. What would be some suggestions there?
So if they're abroad, I would recommend service by DHL. It's a little more expensive, but it's a commonly accepted mail delivery service that requires signature. I've used DHL in Sweden, in Italy, in Philippines, and it's been recognized by the court as a completed proof of service. If someone's avoiding service, you have to go through at least what the court said the statutes say reasonable measures before you go to publication. And so reasonable measures is often interpreted by two options. A personal delivery service like a sheriff or a process server, a private investigator attempting service. And then a second option would be the mail delivery service like USPS or FedEx or DHL. And then if the defendant has avoided service in those two methods, then you go to publication, which is in a newspaper that is recognized in your county for legal notices. And then you have to have the notice posted in the newspaper for 3 consecutive Wednesdays, and the defendant will have 45 days from the first Wednesday that the notice is published. And that one costs more. And then you have to do, again, we did that affidavit of service by certified mail. You'll have to do an affidavit of service by publication, and I'll be honest, there's no form for that in the self-help, the file it yourself packet, but you have to go through and put the details of every attempt of service you made before you did publication. And so it delays it a little bit, but a lawsuit you will not go forward through the court system until service is achieved.
And then someone clarifying about what can a grandparent do. Can grandparents file for custody?
Grandparents have options in certain situations for custody and visitation. That is going to be found in North Carolina General Statute 50-13.2. And I would say if you are a grandparent seeking custody, which is a higher standard, remember, higher standard, that's the acting inconsistent with the parental rights standard. So I would say at that point, that's when you should probably seek at least the 30-minute consultation with a lawyer referral service or a local attorney who can help advise you on what your rights and standards are to get grandparent custody.
Perfect. And I think this is the last question we will have time to answer here. Just some questions about custody and child support. Can you add a custody action to a child support action that maybe if child support was filed first? Or are they totally separate all the time if you don't
They're
file them
not
together?
separate all the time. Oftentimes, they can be in one initial lawsuit. Um, Many attorneys will put them together in one lawsuit. You could file it separately. It's just two filing fees. An example where I will say you cannot just file a motion for custody in a child support case is if you're working with a 4D agency, so child support enforcement, your local county's child support office with DSS, you cannot file what we call a motion in the cause for custody through that lawsuit. You would have to file a new lawsuit through what we went through today. If it's just, one of these lawsuits that we went through today, and you want to file a motion for child support in this custody action, you could do that. But again, you'll have to file that motion on your own.
Perfection. And as we are at our time, I am gonna go ahead and have to say thank you to all of you for joining, with a special thank you to Manisha for presenting. If you would like to review anything that Manisha went over today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access the recording with or without a Facebook account at www.facebook.com/legalaidnc. You for about 30 days. You can also view the recording at any time in about a week on Legal Aid's YouTube page. If you would like to register for one of our other Listen and Learn programs, which I did put those links in the chat at the beginning of the presentation when Manisha was talking about them, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a wonderful rest of their afternoon.
Thanks.